Because
I'm
something's
sorry.
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have
you
a
think
mental
the laws
problem.
in the
How?
United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
In a recent case, attention was drawn to a woman whose courtroom appearance was overshadowed by constant noise and chaos from her surroundings. At the time, her children could be heard throughout the proceedings, creating a scene that distracted from the seriousness of the hearing. That moment alone set the tone for what many expected to be a difficult legal exchange. Today, however, the situation looks very different. The children are no longer present, and the focus has shifted to another family member stepping into the courtroom spotlight. This time, it's the mother who finds herself facing firm guidance from Judge Washington. With no background distractions and no room for confusion, the judge takes control early. What follows is a clear, direct lesson in courtroom procedure, responsibility, and accountability as the hearing officially gets underway.
Good morning. The 14B District Court is now in session. My name is Elaine Washington. And
I find everyone's pain funny but my own. I'm finished.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearance especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today.
This is quite tasty.
Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not,
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
There's a saying that when behavior consistently follows a certain pattern, the outcome usually isn't a surprise. In this case, the conduct and arguments being presented point toward a familiar legal playbook that courts have seen many times before. The approach may sound confident, but confidence alone does not make an argument valid, as explained earlier. Her main claim rests on what is known as constructive eviction. This legal concept applies when a property becomes so unsafe or unlivable that a tenant has no real choice but to move out, allowing them to leave without penalty. On paper, it's a serious claim that requires clear evidence and decisive action. However, that argument quickly falls apart under scrutiny. By remaining in the property and continuing to live there, she effectively gave up the right to rely on that legal defense. Courts view actions as loudly as words, and staying put directly contradicts the claim of being forced out. As a result, what remains is not a strong legal position, but flawed argument that doesn't hold up in a courtroom setting.
well, whatever you're using as your basis is still not correct. It is not the
It
law.
is. It's still under MCL and it's under the Landlord-Tenant Act.
Overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because that's
rescinded?
not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
It's always interesting when someone brings up the law, especially when the statute itself clearly explains the process. In this situation, the legal reference actually supports the correct procedure, even if it's being misunderstood by one side of the argument. The law is very specific about how these cases must begin. Under MCL 600.5716, a property manager is legally required to issue a formal demand for possession before an eviction case can move forward. This step is not optional and serves as the official notice that starts the eviction timeline. Without it, the process cannot legally proceed. The problem here isn't the law itself, it's the interpretation of it. The statute clearly outlines the steps involved, yet the argument being made ignores those details entirely. When legal language is misread or selectively applied, it weakens the credibility of the claim and leaves the court with little choice but to rely on the plain meaning of the statute.
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody, please stop typing. It says, a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there a proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession,
clarify your question before.
I appreciate it.
All right, Ms. Charles, please, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay, that's fine. I didn't cite an exact statute, but I appreciate your objection.
This is a perfect example of how poor judgment can cloud basic reasoning and short-term memory. Moments after making a statement, the same point is conveniently forgotten, creating a contradiction that's impossible to ignore. When arguments shift this quickly, credibility starts to slip. TO makes sense of what's happening. It helps to slow things down and revisit the facts that were just placed on the record. The timeline matters, and consistency matters even more in a legal setting before the discussion moves any further. It's worth pausing to clearly restate what was said only minutes earlier. Once the record is refreshed, the gaps in logic become much easier for everyone in the room to see.
Statute that you cited.
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, everybody. So let's not make my ruling.
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service.
Okay.
It's not on the disposition, and just like she read on 657.16, was the property described on that disposition?
Yeah.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Ms. Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question. where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth
Everybody,
before you
please
objected
just
me.
let her ask the next question. And if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear. I said either federally funded or get federal funds, which you do if you accept Section 8 and voucher.
That argument might carry some weight in cases involving tenants who actually receive HUD assistance. There are specific eviction rules that apply in those situations, and courts do take them seriously when they are relevant. However, relevance is everything in legal proceedings that AS the record is about to clearly show. This case does not meet that standard. The individual involved is not a HUD recipient, which immediately removes those statutes from consideration. Legal protections tied to federal housing programs only apply when a tenant is formally enrolled in them. Because of that distinction, citing HUD-related eviction laws does nothing to strengthen her position. Whether the property has any connection to HUD housing is beside the point if she herself is not covered under the program. In the end, the court must apply the law that fits the facts. And in this case, those particular statutes simply do not apply.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
There is no question that the hearing being provided is fair and thorough. The court has allowed time, explanation, and opportunity for the arguments to be heard on the record. What's happening here is not a lack of fairness, but a refusal to accept the outcome when the facts don't support the claim. Understanding the law is ultimately the responsibility of the person presenting the argument. When the reasoning doesn't align with legal standards, the court is not obligated to reshape reality to fit personal misunderstandings. Judges rule on evidence and law, not on frustration or denial. Most importantly, the legal system is not designed to grant lifelong benefits simply because someone disagrees with the process. A landlord cannot be forced to absorb endless losses due to flawed reasoning. The court's role is to apply the law evenly, not to excuse unsupported claims at someone else's expense.
Battle. Move on.
Move on to, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If
Not-
I cannot have, this is not a fair hearing. And
No,
again, this is
not,
why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
Please move
all
on.
this is not right.
I'm telling you
And
now
attorney
that I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me.
Recently, I covered this infamous Ninder Karen episode where her kids were screaming nonstop in the background. Today, the scene has shifted. Her children are off at school, and now it's her mother's turn to face the scrutiny of Judge Washington. Let's dive into how this courtroom showdown unfolds.
If you feel that it's frivolous, that's fine, but it's not. My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute
cross-examination.
If you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do.
Naturally, you're not exactly new to trying schemes for free rent. You even mentioned the marshals might get involved, but let me clear that up. It won't be the marshals. The sheriff's office is the one handling this, and they'll be showing up to remove you and restore the property to its rightful owner. This isn't a suggestion. It's the law in action at this point. Judge Washington has had enough of her endless nonsense. She doesn't hold back, laying out exactly how ridiculous her behavior has been and making it crystal clear that the court has zero patience for games or excuses. The judge's frustration is evident, and it signals the end of any leniency.
You all have not been acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health. Because something's wrong with you. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action, and I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law.
Even if nobody challenges it, a frivolous motion remains just that, completely without legal merit. Agree with it or not, the court sees right through it and treats it accordingly. Some viewers might argue that the judge should already have all the answers, but in truth, she's fully aware of the proper procedure. Her calm handling is intentional, guiding the complaining attorney to formally request a directed verdict. It's a subtle, strategic move that keeps the courtroom process on track while exposing the baselessness of the other side's claims. The judge is effectively teaching both the attorneys and the audience a lesson in procedure and legal precision.
That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
All right.
backed in case law. And y'all keep muting
Ma'am.
me. It's okay. Because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, you know, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut you off. You just asked me what my defense was. And
all right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes,
Thank you.
thank you.
I'm sorry.
Thank you, Judge Washington.
I'm
Thank
sorry
you.
you had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
Bye.